Macharia, who is legal counsel from Optiven. Karibu sana.
Thank you so much.
How are
thank
you?
I'm fine, thank you.
All right.
Yes.
Karibu sana to our studios.
Asante, thank you for having me.
All right. So, you know, the relationship between tenants and landlords in Kenya, it's quite, you know, ironic, since, you know, there is love and hatred type of relationship.
It's
which
true.
is ironic because no one can do without the other.
Right.
So before even we get into the matters of laws, and, you know, I want to get to know or get a clear picture. Who's Mr. Ian Macharia?
Well, my name is Ndegwa Ian. I prefer using the name Ndegwa.
Okay.
I'm legal counsel at Optiven Limited. We work hand in hand with PMC Estates. I am an advocate of the High Court of Kenya, and I'm very happy to be here today.
All right.
Yes.
So, you know, this being an entrepreneur speech, before I get even deeper into the gist of the discussion,
Right.
someone would be wondering, how did you get yourself in the position you are right now?
All right. I've been very particular about land laws in Kenya.
Okay.
And I'm an avid follower of what is happening in terms of land adjudication and administration of land in Kenya. So after my Kenya School of Law, I decided that this is a line that I wish to pursue. And I thank Optiven Limited for giving me that opportunity to pursue that line in that capacity as legal counsel in the conveyancing department, where we do quite a number of conveyancing work, where we do agreements and quite a number of things. So among them, I also advise PMC Estates, which is a letting and leasing entity, on various rights and obligations of a landlord, rights of a tenant, obligations of a tenant, because as much as you have rights as a tenant, you also do have obligations, which amount to the rights of the landlord. So as a landlord, your rights or your obligations are the rights of a tenant, and they work vice versa. So I've been advising on conveyancing matters for quite some time, and that's why we're here.
All right.
Yes.
Thank you so much for joining us today. This
Thank
is
you.
Entrepreneur Speech, and we do this each and every single Monday from 9 a.m.
Thank you so much.
So tenants' rights are the most violated rights right here in Kenya. So, you know, right to be protected from unfair rent, you know, from unfair increase of, you know,
That's true.
rent also. So what are some of the laws that protect tenants?
Well, in Kenya we have very specific laws that deal with particular tenancies. And I usually group them in two classifications, two clusters. Now the first one is the Landlords, Hotels, Shops and Catering Establishments Act, which specifically provides for business premises. Then we have the Tenancy Act, the Rent Premises Act, which provides for dwelling places regulation of dwelling places establishments, and where you have tenancy, for instance, for an apartment. So that act specifically provides for that. Then we have the general rules, the Land Act, which provides for generally leases, provides for tenancies, provides for charges, but particularly from around section 55, that's where you find leases and tenancies addressed in the Land Act. Then we have the Land Registration Act, which specifically provides for registration of leases. So there are quite a number of acts, and now we have the Tenant Landlord Bill, which is currently being scrutinized by Parliament.
Yeah, sure.
Now this bill seeks to unify these two acts, the Landlords, Hotels, Shops and Catering Establishments, as well as the Rent Restriction Act, into one, so that it can provide for a single provision or a single factor that addresses issues of tenancies. But as of the moment, we have those four acts that I've just mentioned, and they do provide for that.
Okay.
Yes.
So let's talk about increase of rent.
Yes.
Do a landlord need to issue a notice before they increase rent? And under what circumstances are they supposed to increase rent? Because I believe you cannot just come out of nowhere without, you know, tangible, you know, changes. For example, renovating the premises. So
It's
how are you supposed to go about that?
Well, sometimes you have tenants who have contracts. Now you decide between you and your landlord, you're going to have a contract for that particular premises that you're renting out, be it a business premises, be it a residential premises. the most important thing is to have a contract that provides for issues to do with increment of rent. So it is very clear for both parties that maybe after 1 year, rent is going to be increased and at a certain percentage. So there's one scenario where you have the agreement providing specifically for the increment of rent. Secondly, you have issues to do with, for instance, introduction of new taxes on the rent payable to the landlord. Now for this, the burden is usually transferred to the tenant, and in such instances, rent is increased. Then another scenario is where improvements have been done on the premises. Now your landlord has decided that now I'll stop using gravel for the parking, we'll have carpools. Or we're going to have a water facility with water pumps. These are expenses that are borne on the landlord, and they need to transfer it to the tenant because it's a value addition to the experience that the tenant is enjoying. So that is another scenario where rent can be increased. But you have scenarios where rent is increased arbitrarily, and there are remedies which are specified in particular acts. And I'll start with the shops and hotel for the business premises. Now, for that to happen, for you to increase rent as a landlord, you need to issue a 2 months notice on the tenant. Now, this notice, once it is issued, you'll give the tenant an opportunity to revert and state whether they are comfortable with it or not, or whether they will comply with the notice you have given, or they do not wish to comply. Now, this reversion or the coming back of the tenant should be done within a month. You should give that provision. And this notice should be very clear as to why you're increasing this rent. And secondly, it should also give the tenant an opportunity to respond on whether they wish to comply or not. Now, with this 1 month, the tenant may move to the rent restriction, the business premises rent restriction tribunal. Now, this business premises tribunal, or the rent restriction tribunal, shall address any queries raised therein in the application that the tenant has brought to it by way of a document known as a reference. Now, this reference will describe the concerns that the tenant is raising, and shall, of course, seek now to, impurge this notice that the landlord, had given. Now, the business premises will then give a notice to the landlord on the occurrence of this reference made to it, and will invite now the landlord to come and describe or to ascertain the description of the notice, and also describe why they're increasing that rent. Now, this only happens when the tenant or the landlord is giving an arbitrary notice of increment of rent. Sometimes the business rent tribunal decides that this matter before it is of no consequence, or doesn't apply to this particular scenario, and will throw out this particular reference altogether. So it is important for a tenant to realize or to distinguish between a valid notice and also a notice that is given in an arbitrary circumstances.
Okay.
Yes.
All right. Now, speaking of that, is there an instance where a tenant can go to the tribunal and report now the landlord, in the case where they have raised their rent, and so that the tribunal can bring down the rent?
Yes, they can. We have that provision, and the tribunal has such powers. It can issue an injunction suspending that notice.
Okay.
Secondly, it can set aside that notice. It can decide that this notice will not be applied because it is against the tenant's rights. Thirdly, it can vary the rent depending on how it ascertains or the valuation of the rent for that particular premises. And for this to happen, the tribunal has the powers to instruct a surveyor. It has the powers to instruct a police officer to enforce its orders or to enforce its directions as far as valuation of rent is concerned. So they may come back and decide, If you are charging 50,000 and you decide that you're going to increase rent to 70,000, it may go to the site now through these valuers, through its officers who are seconded by the tribunal, and they come back with a report. Now, through this report, the tribunal will make a judgment, a decision on whether the 70,000 is sufficient or whether we should settle at 60,000. Now, I think it's very important for us to realize that once the tribunal has made its decision, this decision as a tenant, I can go to a magistrate's court, a chief magistrate's court, and register it. Now, once it is registered at this court, it is recognized as an order or a decree. Now, this decree is very enforceable, and if the landlord goes against it, they are committing a crime under the penal code, which is punishable by law.
Okay,
yes.
Quite fair.
Yes.
Okay.
But I think it's very important to realize that this happens for hotels, business premises. That is specific for business premises tribunals. We have the Rent Restriction Act, which is in regard to dwelling premises. Now, dwelling premises where we live, apartments, flats, plots, that's where we live. But the catch is that it only applies to premises where rent payable is less than 2,500 Kenya shillings. We are yet to amend that, and the new bill, the Tenant Landlord Act, seeks to remedy that through giving the Cabinet Secretary powers to gazette rent that falls within the jurisdiction of that act on a 6-month basis. So probably 6 months after the enactment, then the Cabinet Secretary, who is responsible for housing, shall have that mandate to enact or to come up with a gazette notice that provides for a cap rate for that particular act. So as of now, the business premises, the Rent Restriction Act applies for 2,500 rent and below. But then we have the Land Act, which provides for generally for leases and rent and tenancies and all that. So it will fall within the ambit of the Land Act, especially for residential premises. And that's where it applies. Yes.
Let's now shift gears a bit and talk about this thing we call eviction, which sometimes landlords use the tactics of bullying, go far, even bullying, the tenants. So, under which circumstances can a landlord evict a tenant? And do they need to issue, a court order or something?
All right. Well, I'll start with the circumstances. I'll go back to the Business Premises Act because it's very relevant to what we're experiencing. Many of us own hotels, many of us own restaurants and bars. So I think the Business Premises Act applies specifically to what we go through, but it is important to also go through the tenancies that we enjoy in our residential places, in our habitable areas. Now, for you to terminate a tenancy, which is now issuing an eviction, under the Business Premises Act, the laws that deal with the business premises, there are particular circumstances are provided in the Act. Now, the first one, the tenant ought to be in contravention of the tenancy agreement that you have. So if you agreed with the tenant that they're not going to sublease or to create a subtenancy on the premises, and they go ahead and do that, you may terminate that.
Sure.
If they fail to pay rent for 2 months, gives 2 months after they had fallen due, then you may proceed as a landlord to terminate the tenancy. If the tenant is becoming a nuisance to an adjacent user, let's say you own 2 adjacent properties as a landlord, and this one tenant is using this property in a way that the next tenant cannot enjoy the premises, then as a landlord, you have the right to issue a notice to terminate. The other one, if you as a landlord, you decide that you want to use this premises for your own benefit, maybe you want to move in, you need to prove that you're going to stay within this premises for a period of not less than 1 year.
Oh, wow.
Yes, so there are particular circumstances in which you're going to be required to prove, even at the business premises tribunal, when the tenant goes and issues or files a matter before the tribunal. So these are the issues that you need to bring out when you're terminating. Now, termination under the business premises tribunal is usually done by way of issuing a 2 months notice, same way as you're increasing rent. And funny thing, even when a tenant seeks for rent reducible, they ought to also issue a 2 months rent, 2 months notice, sorry. So under the Act, all notices issued are issued within 2 months. So for dwelling houses, for less than 2,500, you ought to first approach the the rent tribunal to get a termination order. So you go by way of reference as a landlord, and you tell the tribunal that this person, I wish to evict this person because they have done this, this, and that. So the obligations on both parties in terms of notice are very strict, and if you fail to issue notice, then orders may be entered against you. So it is very important for a landlord to issue notice, and this is to avoid future or to avoid delay when it comes to evicting this tenant, because there's no need of failing to issue a 2 months notice. Then 4 months down the line, you are at the business premises tribunal trying to figure out your way out of it. So just do it through the right way so that you avoid all these conundrums.
Okay. Yes. So I'm just wondering, when we have high number of eviction in a certain premises, does it mean that the property management did not do enough screening
of the tenants?
Yes, yes.
Well, that could be the case. And also, it is important as a landlord to note that tenants do have rights. As much as you have the right to collect rent and you have the right to terminate upon breach of a condition by the tenant, also landlords have obligations. And the first obligation shall be to ensure that the premises are fit for habitation or fit for use if it's a business premises. Right? They have the obligation to ensure that the possession of this particular tenant is quiet and enjoyable. So if they fail to meet these demands, then most definitely the tenants will move out, because if I move in within a premises for a particular purpose and this premises is unable to cater for my needs or facilities, then I have no choice but to move out. So these are the things that we need to establish as landlords. Me not being one, but I hope one day God will bless me with a premises. But as a landlord, you need to make sure that your premises are fit for consumption and even fit for use. Yes.
All right, so I want to get personal with you a little bit. All right. Bearing in mind you're a lawyer and probably you have, handled a case of eviction. I want to understand, how was the process?
Well, it can become very emotional, especially where you have a tenant who's attached to these premises. A tenant probably who has stayed within these premises for 10 years. They have their family around there. They've done so much work on it. There's this one particular case I was going through where a landlord in Karen had leased out some property. And the tenant decided that they're going to effect changes to the property to suit their particular preferences. Now this tenant invested a lot of money in the tune of millions. They decided that they're going to do it themselves and they won't involve the landlord. Now when this matter went before court, court decided that it won't issue a judgment in favor of the tenant because of one simple reason: they did not seek the consent of the landlord. So you need to be very particular, especially as a tenant, when you're making renovations on your property. Make sure you have a written consent from your landlord, so that when it comes to termination of this tenancy, the landlord won't come back and say that we didn't have this arrangement. Or in the event that there are repairs to be done on the premises that should be catered for by the landlord, especially things to do with walls. For instance, you have a leaking roof, you have walls that are falling apart. you need to get the consent of your landlord if you wish to do it yourself.
Yeah.
But it is important to note as a tenant that the landlord has the obligation to make sure that these premises, especially the walls, roofs, ceilings, or windows, are in a repairable state. So they're in good condition and it's habitable, especially for dwelling premises. If the landlord is unable to do that, is unable to make sure that this place is safe for habitation, or is, for instance, there's fire that has been that has ravaged through the premises, or you have a calamity, floods that have made the premises undwellable. If the landlord fails to rectify that, rent is not payable. You don't have to pay rent for that month until the issue is rectified.
Okay.
That is for dwelling premises. For business premises, this rent is taken to the business premises tribunal. You pay to the business premises tribunal so that it also forces the landlord to pay, to make good of the repairs that are pending on the premises. So it is important to note your rights. It is important to realize your rights, which I'll mention them in passing, so that at least even if someone is writing, they have an opportunity to note them. And of course, to make sure that they oblige to the obligations and also take note of their rights. So personally, this was one of the most difficult matters that I have dealt with. And I hope I won't have to deal with that again now that tenants and landlords know their rights.
Yeah, sure.
Yes.
All right, I'm learning quite a lot here. At least now I know my rights. My landlord, I hope he's also watching this, so that next time
Oh, yes.
be a little bit, calm or something. So we're going to take a very short commercial break. But when we come back, we want to understand those rights that you have mentioned. And I know our viewers also want to note 1 or 2, 3 things.
All right.
So we're going to take a very short commercial break. We're live at Facebook at DGTV Kenya. We are also on Instagram.